So we've got time for a few questions if there are any, and Beth is going to. Okay. Is it on?
I wanted to ask, I guess, Carolyn, or really any of you, the idea about using local authority that has been either delegated or mandated. I'm from Austin, Texas, and one of the things in Austin is that at the federal level, we have been mandated to have an NPDES, now a TPDES permit, and to protect water quality within our jurisdiction, what comes out of our storm sewers. And the state has also required cities of over 50,000 to have water quality. It's a requirement. You must have water quality regulations and protect water quality in your jurisdiction. So it seems like, following the argument you were making, or the case that you were making, could you use, while maybe you couldn't use it for siting, but maybe you could use it to require environmental protections, water quality protections that might not otherwise be required by state or federal regulation. Is that kind of the logic that you were talking about?
Yes. I mean, as long as you can get something within the federal wrapper, then you're not going to have the preemption. I'm not exactly sure. I mean, I think that somewhere down the line there may be some dispute over which federal law, trumps the other. But the way that the Natural Gas Act is read is that FERC, I mean, the Clean Water Act, Clean Air Act, and CZMA are expressly carved out. It says nothing in the Natural Gas Act shall affect any powers under these statutes. So if you can tie that local authority back to one of those statutes, then that FERC would have to adopt it as a mandatory condition within the certificate, and you would have enforcement authority either through the FERC certificate or through your ordinary course of citizen suits or whatever other options there are for enforcement under that particular statute. So I think that is a very good approach. Unfortunately, not all of those statutes really always drill down to the local level, but many times they do. The other point about local authority is when you exercise the federal right, you have to make sure you're doing it correctly. I'm not sure if this is the case that Rebecca had mentioned, but there is the AES liquefied natural gas facility where the city of Baltimore had adopted a zoning ordinance saying, we don't have we don't allow LNG here, and even though initially the federal district court said that would, it was exercised under CZMA and it would block the facility, on appeal to the Fourth Circuit said, well, you didn't do this correctly. In order for your local law to be encompassed within CZMA, it had to go through these other hoops, and so because it hadn't gone through those hoops, it didn't get that federal protection. So if you do have the option for that protection, and there's a series of steps you have to go through. I mean, for example, like with Clean Air Act, a state has to get its implementation plan approved by EPA in order for it to get that federal authorization. So if you do have the ability at the local level to get your laws federalized, so to speak, you just want to make sure that you comply with whatever process is in place for doing that. And it sounds like Austin has had this in place for a long time, so it's not an issue for you. I was just mentioning it for other communities that might be considering that approach. Yeah.
I just want to add a little bit of a different wrinkle to it. The hazardous pipelines category that you have in your zoning covers those things that are not regulated under the Natural Gas Act. It's hazardous liquids, it's natural gas liquids. Certainly under either set of whether it's a methane line under the Natural Gas Act or it's a line that is regulated under the Interstate Commerce Act, they have to obtain permits under 404 of the Clean Water Act for any dredging or filling activity dealing with waterways. As part of the Corps' approval of a permit, they go through two processes. One is the Section 404 guidelines, which is have you avoided impacts, have you minimized, have you mitigated. But they also have what's called a public interest review, which is a wide-ranging federal review of taking into account lots of things other than just aquatic impacts. that is a potential vehicle for convincing the Corps that the particular routing is not in the public interest because of the risk it may pose to a waterway. The other approach is the Corps will not issue a permit if the state has not issued a water quality certification for that project, either a blanket certification or an individual certification, depending on the activity. And in those cases, we've got a situation where they want to cross upstream of the water intake for a community in northern Kentucky. And one of the issues that I've suggested they look at, in addition to potentially zoning and saying that is an inappropriate place to be crossing, you need to cross below the water intake, is to talk to the state about the fact that this interferes with their water management plan, because it presents a risk that, of if there's a catastrophic or even a less than catastrophic leak, before they could interject someone in order to address the problem, your water supply is down. So you've got the 401 water quality certification as well as the Corps' public interest review, both of which are clearly protected under the Natural Gas Act as well as under the Interstate Commerce Act.
Are there other questions? Just a sec.
How would you assess the readiness level for most township and borough solicitors to be able to provide this type of consultation to their local elected officials? And what's being done to kind of raise the bar among many of these solicitors?
The bench is not very deep. Okay, you've got folks who are very concerned, but obviously the technical issues are beyond a lot of the local capabilities. And because this is a fairly recent vintage that we're dealing with this, as opposed to the natural gas lines the utilities have in place and the infrastructure that's been there for some time. What we've suggested to communities is it's well within your rights to charge a fee that is sufficient to hire someone to be your technical advisor for the zoning or the conditional use process. I think in many cases the company would prefer that, because they'd then be dealing with somebody who has the capability and the expertise, and it wouldn't be such a steep learning curve on their part. And so we think that's kind of a win-win for communities. We have a similar thing. We have a state siting board for merchant electric power plants and transmission lines, but not this type of transmission line. We have it for CO2 lines. And the state siting board process provides that you pay a certain amount in and they reimburse whatever they don't spend, and they hire a third party to do an assessment of the project. So this would be very similar on a county or a township basis.
Just to add a little bit to that, my own assessment is just based on the calls that we get, and we're also on the receiving end of those calls of people in crisis. Some of them are local government representatives. The state of readiness is pretty close to abysmal, both in terms of the technical capacity, but probably more importantly because there's a learning curve for technical capacity, but they simply don't have the funds. There are part-time elected officials, typically part-time counsels for lawyers for a lot of these local governments, and taking on a project of this nature, even in terms of the planning capacity and advising people in terms of planning issues, let alone defending a lawsuit if there were an eventual challenge to something that the local government did, they're in no position to be able to do that. Sure.
Yeah, this is for Tom. So I gather this correctly, what you said, that an NGL pipeline does not have to meet FERC's need.
Right.
But yet you could pump natural gasoline through that, since that's classified as an NGL, but yet refined gasoline would have to meet FERC standards.
There's no rational distinction. It's simply, historically, the natural gas liquids were in the same line, particularly the ethane. Depending on where the market is, it's going to stay with the methane in the first place, and the rest of the production was flared off or was dumped out at the compressor stations and burned. It is only a more recent phenomenon that you see and in part because a lot of the NGLs were shut in. The capacity wasn't there historically. We have a lot in eastern Kentucky where they had to truck it, to the railheads and take it from the railheads out. There really is no rational basis for other than the fact that the Natural Gas Act, covers, it's narrowly construed to cover methane. And but there's no rational distinction from a public policy standpoint why you wouldn't extend that scope to provide a similar process. Because we may end up with two projects here, neither of which is going to be able to be viable. One of them cut short their open season, and I'm not sure what the reason was, but it may have been they weren't able to get the subscribers that they needed. Because you have two of them that both have an open season right now and are both trying to get that 400,000 barrels a day capacity that's there. Plus, you've got competition from a plant that wants to fractionate it up in West Virginia and send out product rather than the undifferentiated NGL. So there is no rhyme or reason to it, really.
So I think our time's up, and I want you to give us bonus points for 3 lawyers ending on time. And